Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Well, hello, everyone, and welcome to another episode of whatever media we are putting forth in front of you today. My name's Chris Aguiar. You may recognize my voice. I was just on one of the intros, although I do sound a little bit scratchy today. Don't tell anyone because I'm in the office and I don't want to get thrown out. With me today, Cindy, do you want to introduce yourself?
Sure. I'm Cindy Merrell, and I am a senior recovery attorney with the FIA Group, and I am out of the Louisville office today.
I didn't actually tell anyone who I was. I don't know that I'm famous enough to survive that. So, yeah, everyone, thanks for reminding me, Cindy. Chris Aguiar, I'm a vice president and lead subrogation attorney, and I'm here in the Canton office, although I like to say I'm in Boston, but some people might frown upon that. How's the weather out in Louisville, Cindy?
It's absolutely gorgeous today. We are looking into, I think, the 80s and a perfect September day out here. How about up there, Chris?
You know, it's honestly, I haven't been outside since this morning. It was warmer than it has been this morning, and it's cold as the dickens, as they might say, here in the office. So I don't know if the Louisville office has basically the Arctic coming through its air conditioning system, but here it's cold all the time.
Yes, we have the same troubles. I think that they're trying to get us to keep moving, I guess.
That's funny. That's a problem when I'm basically chained to my desk. Just kidding. I'm not actually chained. I'm metaphorically chained. Anyway, enough with the bad jokes, Chris. So today, Cindy, I guess we're going to kind of chit chat about something that's pretty near and dear to our hearts, right? It's a conversation I have. I spend almost all my time on conversations like this, really. I mean, you guys do too. It's the age-old discussion. If ERISA lets me have 100%, why can't I have 100%? And really, it's such a fascinating dynamic. You know, we work with, business people all over the country, and there's all these sort of misinformation, to use a term that's pretty aggressively used right now in the political sphere. There's all kinds of misinformation about, what our plans entitled to / required to do, and to what kind of length should a plan go to get what they are, quote, entitled to. Because as we know, the law, ERISA, does entitle a plan to 100%, assuming good language and all this other fun stuff. But as we lawyers like to say, the law is only as good as what you can actually enforce. And so just because it says you can have 100% doesn't mean it's always the best idea to go after that.
Well, I think it's important to keep in mind, what does that settlement represent? Now, when I'm talking about settlement, let's use an example of an auto wreck. And I get injured. Chris, your car rear ends my car, and I'm injured. And if I decide to pursue a claim against your insurance company, what does that settlement actually mean? What are the elements to that settlement? So, we always like to see that there's medical expenses that the plans advance. The plan has paid a certain amount of benefits, but then there's also the members or the patient's other elements of damage.
Yeah, and the fascinating thing about it, and this is kind of what I say almost every single client, regardless of what the damages are, right? Lost wages, pain and suffering, the vast majority of cases in America, we are both a litigious society, but we're not great at protecting ourselves from risk. In health insurance, we are sort of accustomed to not being able to put caps on the amount that might get paid. Sure, we can do that on a claim, sort of claim by claim. But, thanks to Obamacare in 2010, when they lifted one of the most popular provisions of Obamacare, when they restricted the ability of what health insurers used to be able to do, which was put a lifetime maximum on someone's benefits. I think they were capped at $1 million in a lot of cases. And now they can't do that. But in the auto insurance arena, you and I, Cindy, we get to decide how much liability coverage we can put on our car. And I don't know what it is off the top of my head in Kentucky, but in Massachusetts, The minimum policy limit for bodily injury is 2040. I mean, I'm sure anyone on this call, and certainly you know this, Cindy, if I walk into a hospital right now and sneeze, the bill is like $20,000.
Yes, it's definitely frightfully low across the country.
What's the minimum in Kentucky, Cindy?
It's 25,000, but the most shocking to me is in California, for example, the state minimum is 15,000. And
Yep.
keep in mind that a lot of auto insurance carriers, there's certain ones that come to my mind, but you know when you see those names that they are going to be minimum insurance. And when they're minimum insurance, and in our example where you hit me and we're in Massachusetts and you only have $20,000, what does that get us? Where do we go with that 20 grand? Where does that money go?
Yeah, the question becomes how good are the plan's rights? But more importantly, because you could have the best plan in the world in terms of enforcement of a recovery claim, but to what lengths does the plan want to go? Because here's the truth of the matter. I rear-ended you, Cindy, and I really think that you're full of it. You're not actually injured. But my insurance company, I guess, disagrees with me. And so they're going to issue you the $20,000 limits. And the truth is, how do you carve up that pie? Because let's say your medicals were actually, let's say 20,000, let's say 30, let's say 40. It doesn't really matter what the amount is. The point is, how you carve up that pie can get really complicated because here's the reality. The Cindy who was injured is not likely to just walk away empty-handed and be happy about that. And then there's the kind of complicated dynamic of the fact that while the plan and the employer are technically separate entities, for all intents and purposes, it's the employer that's making decisions with respect to the plan. So you've kind of got that weird kind of mix in happening.
That dynamic there is difficult. It can be very stressful for both the employer and the employee at that point.
Right. And look, at least at the $20,000 level, we're not usually talking about litigation, right? We're talking about how do you carve up these funds in a way that's, I hate to use the word equitable, but more importantly, in a way where everyone is happy. And the truth is, there is no right or wrong answer to that because everyone obviously is going to perceive what's happening in those cases differently. No one that's ever injured usually understands that my health insurance company paid with this money and they want it back, but they're supposed to be paying for this. That's what I have health insurance for. Obviously, that's not what you have health insurance for. You have health insurance for when you're sick. The story I always tell, and I won't tell the whole story, Cindy, I used to have a guy that used to get really upset at me all the time about some money he owed. And finally, he kind of ticked me off so badly that I had him on the phone and I said, can I ask you a question, sir? If I had my car and I ran it through your front door, who would you expect to fix your house? And naturally he goes, well, you. I'm like, okay, then how come when I broke your leg with my car, you think it's different? And he goes, holy crap, no one's ever explained it to me like that before.
That is a good way to exemplify that.
It was absolutely just a reaction to frustration. It just came out of my mouth that way. But he and I had a good relationship after. But people don't fully appreciate how it works because, and Adam used to say this all the time years ago when I used to kind of do the travel circuit with him. They're walking around with daddy's credit card, right? Health insurance is daddy's credit card. And they don't have any idea what any of this stuff costs. They're just swiping the card. And so they don't realize the damage they're doing to their kind of own situation when they aren't informed consumers. But yes, that $20,000 is a good example of like, hey, we all should figure out a good way to do this because none of us want to go to court. The reason for that is, Cindy, what would you say is the most money you've ever had spent on an ERISA subrogation case in federal court?
Ugh, full-blown litigation is at least $40,000 to $50,000.
Easy. I had a case one time. We hadn't even walked into a courtroom yet. No mediations, no nothing, no appeals. We basically just got through initial pleadings and discovery. And we were at like 45,000 in costs. And I went back to the plan. I was like, we're going to go double this if we have to go all the way through, plus appeals. God forbid we end up, filing writ to the Supreme Court. So it's expensive. But what folks don't understand is that it's impossible almost. Have you ever had a case, Cindy, where the plan was able to get their fees and costs back under?
No, I have no. A court.
And that's surprising because there's two ways that in theory you could get it. Statutorily, ERISA allows for it, but there's a lot of caveats to that. And a lot of times the plan language has it in there, but that's one area of the plan that the court won't just automatically enforce. They apply all these weird rules. I interrupted you there. Continue, sorry.
No, that's okay. So many times what I've seen is when you have an actual person, a judge, he sees we still are battling. There's an appearance of David versus Goliath. David being the member and Goliath, in theory, they see plans as the deep pockets, and the judge sometimes takes liberties. And unfortunately, in order to explain to a judge, yeah, we might have the best rules, we might have the best plan language, we might have done everything perfect, but it is very challenging. I've never heard of it getting the attorney fees back to the plan.
Yeah, I never have either. In my experience, a few things have to be true. Number one, there has to be a boatload of money available. By the way, I've never seen it happen. I'm just laying out factors that I've seen. If these things were true, then we'd have a shot. Number two, there can be like no colorable argument that the plan wasn't entitled to full reimbursement. You can have no issues on your 5500, which, as we know, almost every form 5500 arguably is filled out incorrectly. You can have no question that your plan language is a slam dunk. And the third thing is whether the assertion of the right is statutory from ERISA or from the plan. What a lot of folks don't know is there's actually a 5-part test the courts apply. I don't know all 5 parts because only one is actually relevant in most cases, but you only need one for the court to say we're not awarding fees and costs. And that is there's an affordability prong to that test, which is why I said there has to be a boatload of money. Because what person in America, besides the few Jeff Bezos that are out there, can just pull into their own pocket and write a $100,000 check to pay somebody else's legal expenses? The answer is almost nobody. The need for sort of perfection on the plan side of the case and the affordability prong make it a practical impossibility in the vast majority of cases. So really, what we're trying to say is the plans are sort of on the hook for these litigation costs, and they're not going to get it back.
So back to our example of the $20,000, and I'm trying to make a claim against you, and my health plan is a self-funded ERISA plan. Back to the question of how do we divide that up? That is so challenging now that we've talked about how expensive it is to litigate and how unlikely it is that the plan will get those costs back. So what do we do at this point, Chris?
Well, I guess the question becomes, did you get a lawyer to represent you, Cindy, or did you just file a claim on your own?
Thankfully, I got a lawyer on this one.
You did get a lawyer?
Yes.
Wow, did you regret that when you found out that my policy limits were only $20,000?
Immediately.
Folks, this is another interesting dynamic of this all, right? Cindy gets a lawyer, and immediately she has now given away a third of whatever the policy limits are. Now, in this case, it's $20,000. So what does that mean? $6,000 are coming out off the top. And while there are some legal arguments we can make to argue that $6,000 shouldn't come off the top, that it is indeed owed to the plan, I would tell you that we'd have to go to Supreme Court of the United States to win that argument, at which point you would have spent another $100,000. So really, we're talking about, in the vast majority of cases, when a participant gets a lawyer, because, again, fun fact, guys, most lawyers, I should say, don't give cases back when they find out they don't have to do a lot of work. Plaintiffs' lawyers, especially personal injury lawyers, the small cases keep the lights on. And so the easy ones are good for them. So Cindy's case, let's say she had $50,000 in medical bills, probably an easy case, but Cindy, the Cindy that's talking to you would know that. But Cindy, the unsuspecting woman that just got rear-ended by me, may not know that there's a good shot she's going to get policy limits with her $50,000 in medicals without a lawyer. Now, that lawyer may do other things like figure out if I have $20,000 limits because I'm, unbelievably wealthy and don't need insurance. But we all know that's mostly not the case. And Cindy may not know the difference. So Cindy gets a lawyer. Now we're not talking about $20,000. I'm no mathematician, but I think we're talking about what? About 14 now?
Yes.
So Cindy, as the participant in this case, how much of that $14,000 do you think you're entitled to?
Oh, I think I should be getting the entire thing. I'm the injured party, right?
Exactly. But I mean, is it really though $14,000? You need all that money?
Yeah, I have massive injuries. I wasn't able to work. I haven't been able to, hold my kids. There's a lot of things going on, and I'm the injured person.
So here I am, the big bad insurance company, quote unquote. Most of our clients are not big bad insurance companies, but let's call a spade. In a lot of these cases, you do have companies better suited to shoulder risk, even if they're not in the business of risk, looking at their employees saying, I'm really sorry, Cindy, that you had all these injuries, that you suffered all this time in the hospital and lost time from work and haven't been able to hold your kids because it hurts too bad. But really, that $14,000, legally speaking, and based on the terms of this plan language, is ours. And so we're kind of illustrating the point here, folks, that no matter what, no one's going to be happy with this outcome. Cindy's not going to be happy regardless of whether she gets the 14,000 because she's kind of messed up a little bit. The plan's not going to be happy even if they got the 14,000 because guess what? They paid 50. And me, the guy who was on his phone texting and rear-ended Cindy, gets to walk away. I don't want to say no responsibility, but my insurance company pays the 20 grand and then I'm free and clear. So there really is no good outcome here. And so in the vast majority of these cases, what happens is, and Cindy, you can pipe in here too, but we end up working out a split. We say, look, we all either are entitled to money or feel like we're entitled to money. And if Cindy were to decide not to take the 20,000 at all, what's the plan going to do? Subrogate? It's going to spend 50,000 to get 20. That doesn't make sense.
The plan would likely need the plan participant to fully cooperate in that. If I'm the plan participant and I'm injured and the plan is telling me they're not going to let me have any of the recovery, I'm not too keen on having to show up to court to try to testify on behalf of the plan to get the plan money.
So Cindy, I'm going to put my plan advisor hat on here for a second. I'm going to ask you to do the same. So I'm the plan. We're debating, we're on the plan side right now, and we're debating what are we willing to do on this case. I'm the plan and you're the counsel, and I'm going to say to you, you know what, Cindy? Under ERISA, I have an obligation to get every penny. That's what my plan language says. So while it's unfortunate that I have to go spend all this money potentially, I'm sorry, I need the $14,000. Why shouldn't I have my $14,000? Do you have a retort?
Sure. Well, Chris, at the FIA group, my client is not going to be willing to cooperate to get the plan back the entire settlement. I've worked to get other elements of damage here.
Well, I guess we're at an impasse then, right? No. But what's important, I think, from a plan perspective to understand is that, yes, the law requires you, in theory, to enforce the terms of the plan in strict conformity with how they're drafted. But as is true with all businesses have an ability to make business decisions. The same is true for a plan. And what a lot of folks ignore, some of the more aggressive plans like to ignore this when we're having these conversations. They like to ignore the concept of prudent plan asset management. And so what I'm trying to say is, sure, the language says we have to take Cindy, the employee, to court to get the full $14,000 back. Yes, in theory, that's what the language says. If you only paid attention to the one obligation, enforcing the terms of the plan as written, you would be right as a plan administrator to say, we got to take Cindy to court. It sucks, but it's just the way it is. But the reality is there is a second equally important duty of a plan. It is the plan's duty to manage assets in such a way that the plan can stay viable. And can anyone in good faith tell me, or that's being reasonable, tell me that it makes sense to spend $20,000 to get 14?
We both know the answer to that is no.
Right. It was a rhetorical question. But thank you for saying it, Cindy, because we have to hammer home the point that, yes, it's unfortunate because in almost all of these cases that are worth money, a plan ends up holding a bag of a significant amount because the truth is, I, the driver in any state, am allowed to say, you know what, I'd rather have a cheaper premium than an extra $100,000 in liability coverage. And so unless those people are, smart and prudent and have assets to protect such that they go, no, what? They do what I do. I don't know what your auto insurance liability protection situation is, Cindy, and I'm not asking you to disclose it, but my sister is my insurance agent. And I remember very, very vividly when I became a lawyer, she came to me and she said, hey, you really should think about upping your policies. I'm like, why? She's like, you're a lawyer now. People assume you make money. I was like, but I don't really make any money because not all lawyers make a lot of money, ladies and gentlemen. But the point she was making was it doesn't matter whether you make money. And so now people will assume you do. Today, as we sit here, I have like a 250, 500 auto policy plus $1 million umbrella. So I have assets to protect and I work in this industry. So I know how this works, right? I don't want someone coming after all my stuff. I spend a lot of money on my stuff. I work hard for my stuff. The point is, folks, the vast majority of Americans do not walk around with 250, 500s and umbrellas, such that there is just an immense amount of money available for us to carve up. The vast majority of these cases, we're talking $50,000, $100,000 policies, and in a lot of them, the plans have paid well north of six figures. So it's a very important kind of issue. You know, the plans luckily don't have to deal with it all the time, whereas Cindy and I literally every day have this conversation. Yeah, I mean, I think that it's an important one. I think plans need to understand that there is risk to litigation. I mean, I just had a conversation with a lawyer in Montana the other day, and we were talking about whether to litigate a case or not. And I'd say to him, listen, I'm not an idiot. I understand that in the Ninth Circuit is one of the most cavalier there is, and that is to say that Ninth Circuit has a bit of a reputation for ignoring the law and making new law, if you will. And so even when the law is in your favor, that doesn't mean you're going to win. Now, you might win eventually, but you lose the first court level. Now we got to go to appeals, and then we got to potentially go further. So there is a risk element to every litigation. Again, remember, you're in a courtroom, you're sitting in front of your employee, a judge looking at this situation, seeing an injured employee. Judges are people too. And so it's just important for plans to understand that while I would absolutely love to be able to wave my wand and just get 100% every time, you know, that would also mean that Cindy might be unemployed because I have the wand, Cindy. That's the only reason why. That's not a reflection on your skills, simply a reflection of the magic wand that I'm holding. All the lawyers here would be unemployed and I'd be very rich. Or someone would steal the wand from me because I'd be like public enemy number one. Everyone would be coming after my wand.
Like the ring.
Hey, exactly. I have the precious and everybody wants the precious. Cindy, I really can't wait for COVID to be over. I've only seen you via pictures and video, but I'm very much looking forward to coming to Kentucky and experiencing all it has to offer.
Yes, we definitely are excited for you
And
to
by
come
all
down
it has
here.
to offer, I'm winking right now. I think you know what I mean.
I know exactly what you mean. There we have some small little distilleries around here that are fabulous.
Fantastic. Whenever the first post-COVID, whatever that week of the Derby you guys have, Thurby or whatever it's called, I'm going to make a trip. Whether the company pays for it or not, I'm making a trip.
Well, we'd love to have you.
All right. Well, thanks everybody for your time. I hope that this has been somewhat entertaining. I try to keep it light, but also informative, and hopefully it'll help you guide your decisions in the future. I mean, we'll be on the phone to help guide you, but you know what I mean. But that's all we got for today. Cindy, always a pleasure. Thanks for joining me. So I'm not just, sitting here talking to myself, even though I could do that for hours, but whatever.
All right. Well, thank you, everyone. Have a good day.
Bye.